Joining us to talk more about the debate is patent lawyer Geoff Karney. He's joining us here in the studio. Joining us live from Berkeley, California is Marcy Darnovsky. She is the executive director for the Center for Genetics and Society. And I thought I'd start off by asking you about Andrew Pollack in a New York Times piece today. I thought kind of frame this interestingly, and I'll read it to you and I'll get reaction from both of you. He said the Supreme Court is poised to take up the highly charged question of whether human genes can be patented. But another question could trump it. Has the field of genetics moved so far, so fast, that whatever the court decides, it has come too late to the issue? Is he right on that? And I'll start with you.
I think he's not. I think there's still quite a bit to be done in the area of gene patenting. And we're talking about other types of genetic sequences where there is a lot of research to be done, a lot to be done in the area of development of new medical products. So I think that may be an overstatement.
Marcy, are they out in front on this one or not?
Well, I think it would have been much better had the Supreme Court taken this case earlier, because a lot of people have been prevented from getting health care that they needed. A lot of researchers have been prevented from doing research that could have advanced scientific knowledge and medical knowledge about genetics. But I think better late than never.
I guess the other question is, this field is changing so quickly. How can you come out with a decision that's really going to stand for the test of time?
Well, I think it'll have significant implications if the court holds that these kind of claims to genes and isolated DNA are not patentable. It depends what you mean, how the test of time. It's certainly going to have, I think, an adverse impact on the biotechnology industry for many years to come.
Marcy?
I agree that it's significant. I think that the impact will be a very positive one on our health, especially in this case on women's health and on the advance of medical treatments and scientific knowledge. It's a time-tested principle that we cannot patent in our country products of nature, and that's at the core of this question. Are genes products of nature? And many eminent scientists, most eminent scientists, the Solicitor General, and the range of plaintiffs that also include women's health organizations, as well as the breast cancer patients and researcher groups and medical groups, all believe that, yes, of course, genes are products of nature and cannot be patented for that reason.
Geoff?
I would disagree with that. I think once you isolate the gene, once you've made significant changes to it, there's a significant utility there, and it's not a product of nature at all. It's a significant advance, but for the action of the people who discovered, who isolated the gene, and perhaps more importantly, discovered the relationship, the utility of the gene. But for those actions, we're not going to have that scientific advancement. We're not going to have the medical things that come out of that.
Marcy, what about that question that Geoff brings up? You know, what's the incentive for these corporations to keep at it if they can't get the patents? And that seems to be one of the core questions.
It is a good question, it, in a way, pits the corporate incentives against our public health. But we do need incentives for things to advance, and companies are, of course, going to be free to patent devices and tests. They cannot patent products of nature, however, and of course it was a lot of work for Einstein to discover that E equals mc squared, but he couldn't patent that.
He didn't make the money that everyone else is trying to get now. Marcy, did you get any sense from the questions from the justices how they may be leaning?
Well, from what I've been reading, there seems to be a lot of doubt on the part of the judges that these patents should hold. So we're hopeful that there will be a decision that will really be a victory for public health and for women's health, and really for the idea that the human genome should be a shared public resource that's managed in the public interest.
Yeah, Geoff, do you get any sense? Briefly, we've got maybe 20 seconds.
I think I would think that it's too close to call right now. I think a number of justices indicated they see the value of the patents on the genes, and we'll just have to wait and see. And you can't draw too much from these questions. We have to wait for the decision.
All right, Geoff, thanks so much for coming in and joining us here in the studio. Marcy, thank you for joining us from California.
Thank you.